Hello, everyone, and welcome to this important discussion and Q&A, Hidden Data, Thriving Threats, Navigating the Legal and Financial Risk of Data Debt. I'm your host, Tony Napolillo, and our agenda today will be a brief introduction of our panel members, the panelist discussion, including the expanding threat surface, the legal maze of compliance complexity, legal liabilities, and the False Claims Act in the cyber era, and the path forward, how to get started. And then we'll have time for Q&A where you can submit your own questions for the experts. You can do that anytime using that Q&A button at the top. And we'll finish off with a brief key takeaways. And patiently waiting for us are our panel of experts. We have Scott Giordano, who is a distinguished and experienced career as a partner and co-founder of the CISO law firm, where he advocates for and serves as a counselor to CISOs. Welcome, Scott.
Thank you.
Julie Bracker is partner of Bracker and Marcus LLC, a boutique law firm focusing exclusively on False Claims Act, QI/TAM litigations. Hello, Julie.
Hello.
And finally, Kevin Coppins, president and CEO of Spirion. Kevin leads a team of data privacy experts dedicated to protecting what matters most for organizations across industries. Thanks for joining us, Kevin.
Hey, good afternoon, everybody.
All right, let's get started with our first topic, the expanding threat surface. Kevin, you have a lot of experience in this space. Why don't you get us started with an overview?
Tony, thanks. And I'm just going to tee up for the smart people that will be coming in later in this call, just to kind of frame up what we know everybody's dealing with today. Dynamic data definitions. We constantly get asked, we are known, the actual SPI in Spirion stands for sensitive personal information. Well, what is sensitive and personal information, and how has it changed? Scott likes to say if it's powered by electricity, it likely produces personal data. But let's go ahead and look at the legal definition of personal data. Sensitive data definitions. Okay, and that's just as of, I don't know, when I pulled it off the internet, there's roughly 765 samples. And since we started this call 6 minutes ago, there's probably 3 new sensitive data definitions that are out there. It's important to understand that because the data that you may have saved 20 years ago that wasn't considered sensitive might now be highly regulated. So understanding the definition changes and the definition, the rules around those definitions change, and your liability, otherwise known as toxicity around that data, can change along with it. Go to the next slide. Here's some of the evolution of that. So pre-internet, good old-fashioned social security numbers and driver's licenses and phone numbers, street addresses, dates of births, etc. Post-internet, regular personal data now includes where I'm accessing things from, machine-readable data, IP and MAC addresses, your phone address, all that other good stuff, geolocation, GPS, log files, etc. Post-privacy regulations, GDPR being the first big one we all know, CPRA following close behind, and the dozens of other ones that Scott will take us through here in a minute. Special personal data is added on top, healthcare data, political, religious data, trade unions, gender preference, etc. So there's a host of additional things that come with that. And now we're in a post-Gen AI world, which is bringing behavioral data to the mix. What is the behavior patterns that you're taking? What preferences are you choosing? Are you demonstrating different emotional states based on how you're reacting? All that stuff can now be told by AI, which brings a whole new flavor of what personal and private data can and will be and how that's going to be leveraged. And the regulations and legislation around post-generative AI-related data is all in its infancy. And the last bullet is mine, but I think you'll find that the concepts around consent have been obliterated. Did I give anybody the consent to use my Facebook post from 7 years ago? No, but it's being used in all the models that are out there. Also creating a host of challenges in copyright law and patent law, which we will save for another webinar at another time and not go into it, but has completely changed the definition of what privacy, personal, and your ownership of that data means. Next slide. Data debt. This is what I was referring to at the beginning. So now, we'd like to talk about the data that you're compiling today, but all that data you've been compiling over the last 10, 20, 30 years. Again, we said it wasn't sensitive then, and maybe now it's very sensitive. And oh, by the way, you probably have managers beating on you to say, give me more data to feed these LLMs so we can have all these business insights. Just keep pouring it in and we'll be much smarter. That's what it said in the Wall Street Journal. You got to be very careful with that. The example that I'd like to use, go ahead and build the next slide, that makes it common sense for just about anybody. An example of data proliferation over there on the left, you are now joining a company. The first thing they ask you for is to fill out your I-9 form so you can get paid. When you do that, you are required to show two pieces of documentation, typically a passport, maybe a social security card, maybe a driver's license. And I would like to say you then go into a secure room and you photocopy that on a secure machine. You hand that over in a closed sealed envelope over to HR, which never ever happens. You take a picture of it with your phone. You then go ahead and send it to the recruiter. The recruiter then sends that off to their boss and possibly the hiring manager, who then, by the way, blind copies themselves before they send it to the senior hiring manager on the mix, which is also then copied to OneDrive. Maybe they send it to their personal email as well at home. You now have that simple, I need to start working here. Your passport information is now in 53 different locations, probably in a matter of about 15 minutes from you sending it. So data proliferates like crazy, and that sensitive data that we just defined just adds to it. So where does it go? Where it goes everywhere. It's in your email. It's on your hard drive. It's in the cloud. Go ahead and build that up, Tony. You have people migrating to the cloud. I have customers that say we have everything in the cloud, and then you say, well, including the stuff on your hard drive. They're like, well, no, that doesn't really count. And I say, well, how big is that hard drive? They say it's 1 terabyte. Oh, okay, so maybe it should probably sort of count. So it lives everywhere, anywhere it can possibly go ahead and get. And we prove that every single day with what we do. Again, as Scott likes to say, for every two applications you believe process personal data, you'll find a third that you didn't know about. And Scott's now going to say, that's great, Kevin. There's data everywhere. We don't know what it is. One of the questions I always ask is, how much data do you have? Do you say grace over to whoever the person is? And they scratch their chin for a moment and say, I have no idea. Say, right, the fair answer. Now, based on that data that you have no idea how much of it you have, how much of that would be regulated or defined as sensitive data? And the answer is, I don't know. And that brings us into the legal maze of the liability that brings with us. Scott.
That is a fabulous segue. And the answer is, with respect to how much of it is sensitive, lots and lots and lots. And that's a legal term if you ever heard one. So before I dive into this, though, I really want to talk about a little bit about the history of data privacy laws going back 50 years, because that's when all this really happened and really started. And what was very interesting is that it plodded along from the late 1970s, actually the early 1970s, all the way to 2013. So you think about all the laws that we're so familiar with nowadays, like HIPAA and GLBA, those happened in that 25-year-ish period after the very first privacy law that came down, the Privacy Act of 1974. So they came along slowly and very deliberately after the Snowden revelations happened in 2013. And just to recap, Snowden was a contractor for the NSA, revealed all kinds of things that were improper, that were being done with personal data and with just looking at data, personal or otherwise. And so those revelations supercharged the legislation that followed, including GDPR, which probably occupies a good chunk of your day. If you're interested in being on this webcast in general, you're probably spending some time on GDPR. So we had GDPR rollout, and then we had the CCPA rollout right after GDPR went live. CCPA was passed, and then we had others that came about. And really what's important is that GDPR model, which was supercharged by Snowden, really then became a model for everything else that followed. So for laws outside, like the LGPD in Brazil, but also here in the US, the CPRA, which updated CCPA and added additional classes of sensitive information. How about that? And also talked about what you could and could not do with that. So it was really an interesting dynamic of how this all developed. And here we are today. This chart doesn't cover all the privacy laws we have. We've probably added another 15 or so since I developed this. But really what's important is that they all typically are based on CCPA or something very close to that. So with that as a backdrop, let's talk about some threshold questions. So I just worked with a client on their posture, if you will, for data protection. And these are the questions that I ask. And this is the questions that I asked of a lot of their employees when I was interviewing them. What kind of data do you have? It doesn't take much to be considered sensitive, and sensitive, not just sensitive in the sense that it's personally sensitive, but it can be sensitive from a corporate standpoint. And I'll talk about that on the next slide. How much do you have? So the old saying about quantity has a quality on its own. Think about geolocation data, because that's a very hot topic right now. A week's worth of your geolocation data, which incidentally will come from your phone, is something that would tell all kinds of things about you. It's remarkable, quite frankly, of what you can be, what can be exposed by just looking at your geolocation data. And I study this with regularity because clients ask about what are our limits, what we can do with geolocation data. So it's truly, truly amazing where it's located within your information ecosystem. So there's this idea that there's a lot of data in your ecosystem that you're just not aware of. And in fact, the annual Verizon reports on breaches and breach notification and what have you, years ago talked about this idea that about a third of the data that's stolen from victims of breaches is data that the victim didn't even know they had on their own network. So the idea of where something is located within your ecosystem is so crucial, because unfortunately the bad guys are very adept at finding things that you perhaps were not necessarily looking for. Other point is what's being done with it. So one of the interesting items on CPRA is that for its definition of sensitive data, it's not just the sensitive data, it's also any inferences that are being made from it. Fascinating study or studies done on accelerometers, so things that are in your cell phone right now. The things that can be inferred from an accelerometer, and I'm going to read from this because it's remarkable. Health condition, body features, whatever that is, gender, age, personality traits, and emotional state, which goes back to what you were saying earlier, Kevin. So this idea is that's from an accelerometer in your phone. Okay, and that's not the only study. I've read other ones as well that confirm that. It's remarkable what inferences can do. So that's important to understand. And then finally, who has access both inside and outside your organization? I think you're probably all familiar with the whole Cambridge Analytica scandal and vis-a-vis Facebook. Facebook suspected that they were up to no good, and they interviewed them, but Cambridge Analytica just said, "Oh no, we're okay. We're not doing anything wrong." And of course, Facebook found out the hard way that they were doing bad things. So it's really a question of who has access both inside and outside your organization, and what are they doing with that data. So our next slide. So I'm not going to go through all of these, but some of these are just very interesting in the context of what qualifies as sensitive, because it's not just, again, personally sensitive, it can be sensitive vis-a-vis the corporation. So we're all familiar with personal data. We've talked a lot about that. What's interesting is here in Washington, where I live, we have what's called My Health, My Data. It's ostensibly applies to healthcare data, but the reality is that they've expanded that definition so widely that it's almost a general data protection law. And what's interesting is that what's considered sensitive is geolocation data. Again, we keep coming back to that. It's a very, very hot topic. And there's a private right of action, meaning that if your rights are violated, you can hire an attorney and go after the offender. So it really opens up a lot of opportunity for litigation. You're familiar almost certainly with things like GLBA and all of those financial laws. What's interesting about PCI DSS is that it's not just your environment that you have to worry about. With PCI DSS 4, it's any environment that can impact the security of your cardholder data environment. So it's really interesting, the scope creep that we see with these laws and why it makes data that perhaps we consider just regular data, if you will, it creates a certain degree of sensitivity towards it. On CMMC, which is those of you that are defense contractors in this call, well-versed probably already with controlled unclassified information and all the things that can go wrong with it. And in fact, my colleague will talk a little bit more about when things do go wrong vis-a-vis the FCA and what have you. But that's all stemming from organizations' inability to properly protect controlled unclassified information. And so all of these different laws that are implicated here, again, I want to emphasize it's not just traditional personal information. It's all kinds of other information that you would likely consider to be sensitive, even if it's not personally so. Event data, like logging data, super important for breach notification, because to be able to unwind what happened to an organization is critical. A lot of organizations don't even keep logs because logging can become very cumbersome, but it's an art or a science that's so important to master simply because of all the breach notification requirements. And for AI, I know Kevin mentioned AI a lot prior to this. And what's interesting about AI is that when personal data gets baked in to a model, as Kevin alluded to, once it's personal data is in, you can't get it out. You can't unbake the cake. And that's a big challenge, because then you have to account for that. Under the new Colorado law that's coming up beginning of next year, you have to be able to have full transparency of what's going on with personal data that you've trained on. And that's a big burden, and I don't think companies are ready for it. So just some examples. Let's continue.
So Scott, just a comment on that as you're continuing.
Sure.
One of the things
Sure.
to make that easy, I think, when I explain that to board level folks, explaining what prompting out means, to make it simple, it's just another vector for data loss. So for the data protection professionals on the phone, now I can take it out on a thumb drive. I can go ahead and email it out. Now I can prompt it out. It's another vector for data loss. And that data loss happens inside the LLM, which is the data that you feed based into it. Prompt is the exit mechanism, or the egress, understanding what can possibly be egress, the protections around it. So it's another vector for data loss that needs to be protected in different ways.
Absolutely. And in fact, there are new standards coming online, hopefully this summer, simply to address prompt injection, which is what you're talking about, the idea of putting in a prompt to trick the system to coughing up personal information. And unfortunately, it's fairly easy to do. So yeah, great point. In terms of the question, what do you mean by sensitive? I drew this from the California Privacy Rights Act. So this is what's considered to be sensitive. And I highlighted a couple things because we're seeing a pattern here. I've been talking about precise geolocation information a lot. We all know that's sensitive. What's interesting here is that a consumer's mail, presumably their snail mail, their email, text messages, all considered now sensitive information. That's not something that even the GDPR does. So I think it's very interesting that that was considered sensitive, because now that mandates additional controls to make sure that's being protected. You have this idea of neural data. So this is remarkable to me, at least, that now neural information about your nervous system, which evidently didn't fall neatly into healthcare information for whatever reason, has now been called out separately. What is neural data? Great question. I don't know. I don't think the legislature knew, quite frankly, but it's another example of how we have scope creep here in terms of what's considered sensitive. In this case, it's personally sensitive, but the idea of scope creep, I think we're seeing through all the categories I just showed you. Let's continue and talk about some challenges that we're having. So a couple things. One is that there's this idea of accounting for AI. So training on personal information. I mentioned the Colorado law here. In California, we have this coming online as well at the beginning of next year, AB 2013, which you have to disclose personal information that you've trained your AI on. And so it now raises the question, okay, do you track where that information is? What do you consider to be personal information? So all of that has to be thought out before the AI gets trained. My guess is that a lot of these were trained and there was really no attention paid to what kind of personal data got sucked up into that. Also, transparency on contractual levels. So this is something that I deal with every day, where counterparties say, I want to train on all of your client's data. My client says, no, you're not going to train on anything. And then the battle continues. And this is every single contract now has this battle that you're going to train on this, or no, you're not going to train on that. And if you do, we're going to punish you. And we have this dynamic going on constantly. It will never end, unfortunately. Policing your business partners has now become a big issue. So the Healthline case that just came down, I think a week or two ago. So you're probably all familiar with Healthline. They have articles on all things health. Well, what was interesting is that because they're subject to CPRA, there are requirements when they work with advertisers of the data that they're sharing with those advertisers. The advertisers have to follow those rules. And in this case, evidently Healthline was not policing their advertising partners. There was no in place any kind of a standardized stipulation saying this is how partners are going to be handling personal data. That's a violation of CPRA. And Healthline got fined a little over $1.5 million. So it was a big deal. The equivalent of that is in CMMC. So those of you in the defense sector, the idea, the one thing you never want to hear that you hear all the time are flow downs. The idea that someone upstream from you in your supply chain is making you do all kinds of things that you're likely not prepared to do, including protect and identify what qualifies as CUI. This is something I did years ago, working for clients, where I spent all my time just looking for the CUI that had to be identified, had to be protected, because downstream, when they were sending the information, if they didn't identify it and the downstream partner didn't protect it, then the onus was on them to justify that. That's the kind of thing that will create FCA, False Claims Act problems for partners. So finally, the EU data alphabet soup. So these are all laws that either have gone live or are going live, and they all have some aspect to sensitive data. It doesn't have to be personal data. It could be any kind of data. For example, DORA, which is really, think about financial data and financial institutions. That's a super law, if you will, that just covers those. So this is something that everyone that works in the EU or has any kind of relationship with partners in the EU is going to have to either comply with directly or indirectly. And I think we have one more slide in this, Tony, if not mistaken. And yes, it's right there. So why your data inventory is crucial. So just finished a project, data inventory with a client, and I learned more about the client through the data inventory than I did through all the other prior interviews that I did. So it's remarkable because the data inventory really serves as your single source of truth. Okay, you find all kinds of things that you probably wouldn't have found before when you develop a data inventory with a client. It's your foundation for all your data maps, DPIAs, all those kind of things that are derivative of that. Very important, especially for DPIAs. In fact, probably a third of your DPIA is done just by developing a really well done data inventory. And then also in the first place, DPO is going to check if something bad happens, if there's a breach or there's a suspicion that something's gone wrong. They're going to pull up the data inventory and cross-reference that to what server it is and who had access to it and what are the legal protections it's supposed to have. So very quickly they can get up to speed on what they're dealing with. And then finally, developing a data inventory, every single time you find all kinds of surprises. Data that you thought or the client thought was deleted is in fact not deleted. Some of the data is still being used. Some of it was on a server that no one touched after someone running a project left, and it's still floating around there to be found by bad guys. So long story short, it's amazing the surprises you're going to find when you do a data inventory. One of the reasons why it has to be done.
So Scott, two things as we
yes.
tee up Julie's conversation. Yes. The surprises, I guess I'm someone in the surprise business. I just talked to a former client the other day that's at a new location, was telling me about they had graphs that they distributed across the entire company. So just good macro data, totally scrubbed, just kind of explaining what was going on, which linked directly back into source files that had millions of credit card numbers on them. So just because you think something, that the surprise that was found is, what do you mean that data is over there? Why is it there? Well, it's used as a presentation layer over here. That's part. And then the other one, that we get so lost in credit card data and we forget about employee data. And there was one just yesterday, Krispy Kreme, for those munching on donuts as we speak, class action lawsuit from 160,000 employees. This is especially relevant retail that has high turnover. They're collecting job applications and job applications. And there was one, I think it was Five Guys and Fries a few years back, where they had one server that was collecting all of the online applications. Go ahead and work there and think about all the information that you capture in a application online to go ahead and turn burgers and fries over. It was amazing the amount of data they were storing. So looking at what you're capturing in the first place will help with some of those surprises. But once you have that surprise, or if you're sitting there going, you know what, I think I have decent control and I don't know about this, I don't know this, so I'm just going to say, I'm going to check the box that says I am fully aware of all the data that I have and I'm fully compliant, and you're not, that's when Julie gets involved. So I'm going to go ahead and hand it over to her.
Thank you so much. And I'll say, if you just pause right here for a second before we get into the meat of the FCA, I just want to share a little piece of why I am here and how I came to be here, because I think it's relevant to those of you who are listening. And I want you to understand why I have deep knowledge on some things and nearly none on others. I have been a cyber plus one for 35 years. So my husband started in IT. He started way back when databases were brand new, and he proceeded to do consulting until he wound up at Cox Communications here in Atlanta, where he was hired. His team developed Cox.net, and then he was hired on permanently to run that program. He decided it would be more fun to get a law degree than a MBA. There's no accounting for taste. And so he went back to school at night here at Georgia State, and with the idea that he might go into tax law or maybe into other statutory areas, the kind of thing that makes me drill a hole in my head to let the boredom drain out. But he's that guy who likes to read the statutes and know all the things. And I have a feeling he and Scott would really hit it off just looking at these slides, because Scott has put together the most beautiful timeline that I can't wait to show to Will. That is actually my lifeline. My story is illustrated by that timeline. Just as Will graduated law school and became an official bar member here in Georgia, Cox was hit with what was developing as the California Consumer Protection Act, and they needed someone to do statutory evaluations of it, and they didn't really have anybody who, the intersection between lawyers and IT people was not very close back then. We see a lot more of it now, but not very close back then. And so they repurposed him. They assigned him to a sleepy little department at Cox called the CPO's office. And to say that it was sleepy very briefly, and then it sprang to life. In fact, the year that the California Consumer Protection Act was on the board, we went to a Halloween party by the Home Depot, CPO Home Depot here in Atlanta as a friend, and we went to their Halloween party, and we were instructed to dress as the scariest thing we could think of. So he went as the CCPA with I got him a fedora and put CCPA here, but I kludged together a bunch of suits that didn't match and, loosely stitched them together, because I think that was pretty illustrative of those early days of CCPA. And he's coming at it from a business angle, right? And Cox, being a large and private company, had a lot of investment in the California area and at a seat at the table. So he became a member of the State Privacy and Security Coalition, which was working with all the states to do all of these laws. The Virginia one was coming out. Oh, I'm like, oh yeah, that was when we were in, I tagged along as a +1 to a cybersecurity convention. So we started doing a lot of that. He started teaching it back at his alma mater, and now he has left Cox to be a privacy and security counsel. And so we say you get a choice. You get to pay his fees, or you might have to pay my fees. That's our running joke. That started out, and I say all that to say one thing I thought would never cross over would be our two fields of law. First, there's the fact that he likes that statutory analysis type law that, again, is not my favorite. And also because I deal with people who contract with the government. And the thing that distinguishes a False Claims Act case, which is fraud on the government, from a regular breach of contract is that, number one, you did it on purpose. You knew better, right? Because you have to know better in fraud. And secondly, you have to have, it has to be material to the contract, right? So there's a lot of, if you've ever signed a government contract, there's a lot of stipulations and riders and all that, like buy American. If you're doing a construction contract, you're supposed to use American goods. Would we be able to bring a contract saying, you didn't use American goods? Absolutely, if it was like you were supposed to use American steel to build a building and you didn't, and you lied about it. If you had a swingline stapler manufactured in China, no, that's not really a violation. It's not a material violation. It doesn't go to the heart of the contract. And so that's, I'd had a hard time, again, pre-Edward Snowden, understanding how anybody would ever say that cybersecurity was material to the government's contracts. And I guess the government was kind of thinking the same way. Well, I'm going to want you back up if you want to go to the next slide. Lincoln's Law is what the False Claims Act case, False Claims Act itself is normally known as. Lincoln, it was passed in the Civil War because people at that era, with the communications that we had available to us, communication systems, people would do a contract for horses, and they would send mules or they said spavined beasts, which I think means they were in pretty sad shape. They would send supposedly flour, and it would show up and it'd be infested with weevils. They sent uniforms that were made of like coffee filter material, not actual like paper, basically. And by the time the government got the goods, it was relayed back to the DC that these were bad goods, though they were long gone. So it was very difficult to catch the fraudsters. So they specifically called it, it's actually not thief, it's set a rogue to catch a rogue, but set a thief to catch a thief. If you'll rat them out, we will give you a share of what we recover. And I say that to say most of my relators are not participating in the fraud. Some of them have, and they've had changes of heart, or their conscience has troubled them the whole time. But the first thing many defendants want to say is, well, he did it. It's like, it doesn't matter. That's the whole purpose of this statute in its very inception. It's based in English law, where people, where the king didn't always talk about bad communication. Back in the day, they didn't, it was by horseback. That was about the only thing they could manage. And so you would have people who knew about a problem where the crown was being robbed, taxes not being paid, fill in the blank, and they authorized people to bring a suit on behalf of the king and themselves and then receive a bounty for it. So this is what it's modeled on. It's one of the very few, in fact, I think it's the only remaining Huitan statute in the United States. I don't know what they have left in England right now, and there is a current constitutional challenge going on to this. We settled it 20 years ago. I don't think that, I'm not worried, and we can talk about that if people have questions, but there is a constitutional challenge going on because it is really weird. You're basically bringing a lawsuit as a witness. I saw this happen and I'm telling you to decide what you want to do about it. It went away pretty much, it happened during Lincoln's era in the 40s when we had all of the war going, a little bit of war happening in the 40s. And as a result, the government was inundated with lawsuits that they already knew about. So they passed what became known as the government knowledge bar. If the government already knows about it, you're disqualified. And then they didn't really very well define that, and they pretty much killed the statute. It was reawakened in the 80s. I remember, as I was but a girl at the time, I assure you. But I remember the age of Reagan, we would hear about these $500 toilet seats and $60 hammers and all this nonsense. So as a reform on that, Chuck Grassley brought forth the amendments to the False Claims Act, and it exploded because first we had the typical kind of military procurement cases, but then people realized this is aimed at anybody who does contracting with the federal government, if they're defrauding the government through contract. So in the early 90s, we had the first cases aimed at Medicare, and that is a huge spend for the U.S., huge spend, our biggest spend by far. And once it was Medicare was brought under it, we were off to the races. And I've got a list of other statutes there, how it has been dealt with. It has, since that renaissance in the 80s, it's only been expanded. It's never been contracted, but it is a very volatile law. Like I said, we have a constitutional challenge right now. I don't think I've been practicing in this area for over 20 years. I will pause so that you can gasp and say impossible, impossible, Julie. But we've been, during that time, I don't think I've gone 2 years in a row that one of the three executive branches hasn't acted actively on my statute, making some of my cases better than they were and some of my cases dead. So it's a very unusual area of the law. And if you want to go to the next slide, I'll tell you while you do that this is why it keeps getting expanded. Since fiscal year 2010, annual recoveries have topped $2 billion every year. And this is basically found money coming back to the government. This year we had, in the past fiscal year, we had over 1,400 cases filed. That's the most that's ever been filed. Two reasons for that. One, I would like to say, is the Civil Cyber Fraud Initiative that I promise we're going to get to in just a minute, but also PPP loans and all of the CARES Act funding that was kind of sprayed out without any caution at all across the country. So that accounts for some of that coming up, but we had $2.9 billion recovered in 2024, and that's actually down a bit. And I've got the statistics there. 83% of that was from qui tam cases. And I want to give you a little inside baseball. People say qui tam, people say qui tam, people sometimes say tom, but that's only if you want to sound snooty. it's Latin. So just like you would say quid pro quo, not quid pro quo, it's a QU sound. So now you know, and you can correct people. So 83% of that came from qui tam cases, 57% from healthcare fraud. That's actually lower than in most years. 3% from defense procurement fraud. I'm hoping to see that number go up as we deal with these civil cyber fraud cases, and the remaining from other federal agencies. So let's go ahead to the next slide. Basically, the FCA is implicated if someone lies to the government to get money that they're not entitled to, which is submitting a false claim, is what it's called. Or if you lie to help someone else get money. So you could cause them to submit. So when a doctor tells a biller to load something into the billing system that's false, he's also guilty. He doesn't get away with it by saying, well, I didn't put it in there, she did. But that doesn't work. Or if you lie to keep money that you're not entitled to keep, then that's a reverse false claim, right? So if you lie so that you're not subject to a penalty that you would otherwise be subject to, then that's a reverse false claim. And the same thing goes if it doesn't matter if you personally click to go on the billing or the keep it. It's if you cause that submission, then you're liable for it. So you can see, go ahead and we'll go to the next slide. And you can see anyone who does this is liable to the government. This is straight out of the statute for a civil penalty of not less than 500,000, excuse me, 5,000 and not more than 10,000 as adjusted by the Inflation Act. And I'm going to pause there. Right now, that is per claim between $14,000 and $28,000 that you would be paying per claim. So that's every time you ask the government for money on that contract, which in a grant that has 4 drawdowns in once a year, maybe that's four claims where you lied. But in a situation where you're doing monthly billing, you're doing it once a month. If you're a doctor, you're doing that constantly. The penalties would far outstrip the damages. But then take a look at there. That's the basic what you're going to pay, and that's again if you lose at trial, plus 3 times the amount of damages the government sustains because of the act of that person. So note that it's treble damages, which is really statutorily consistent with the fact that a relator who brings the case can get up to 1/3 of the recovery themselves. So even if the relator's given, and again, we're talking about this is what happens if you lose at trial, then you're going to get, the government gets back 3 times, the relator can get up to 1 of those times, and the government is still getting double damages, and it's all coming out of the pockets of the bad guys, which I like. This raises 2 questions, or this raises a question for cybersecurity cases. What is the measure of the damage, right? So if I build a building out of Chinese steel, assuming there's such a thing, I'm not an expert on steel, but if I build that building out of non-American steel and I still got a building out of it, how have I been damaged? How are we going to evaluate the damage to that? And in the case of cyber security, the first thing a lot of people want to say when I speak is, well, we haven't had a breach. And to which, because I've been a Cyber +1 for a long time, I say that I bet you don't have audit logs. And I'm almost always right. Maybe you haven't had a breach. Maybe you just don't know you don't have a breach because your cybersecurity is that poor. And what we're talking about is that one middle band on the wonderful chart that Scott showed us about CMMC. And then if you looked below that, it also referenced DFAR 7012, right? So the DFARs have been around a lot longer than the CMMC has. And just as a pause, for those of you who are involved, if you've been, I think CMMC involves a third-party audit, which means that the C-suite suddenly should be paying attention, right? When it came out that you would now be certifying your cybersecurity compliance with NIST 800-171 for covered defense information, your company started signing for that if you're doing business with the government January 1st, 2018, so about 7 years ago. You've been saying you're compliant. So yeah, there's CMMC, and if you're not CMMC compliant, meaning that you're not going to pass that CMMC test, you've been lying for 7 years. And that may have been an unknowing lie. And again, you got to know it. That may be your defense. I didn't know. But there is a concept of you should have known, because I asked you, are you doing it? And you said, yes, you signed. So the day for this was 7 years ago. And I stress that because CMMC's novelty has a lot of people kind of scrambling. And I think that leads to people then whining about not wanting to do the spend. But my friend, you've been saying this was already done. It needs to be a top priority. The civil money penalty, I have up there that it has been adjusted for inflation now, and it's mandatory if you lose at trial. And I've talked already kind of about what a claim is. So if we want to go on to the next slide, I'll tell you that's why a lot of these cases settle. Government typically tries to settle the cases on a double damages instead of a treble damages posture, and that ought to be very attractive to you if you're in a bad case. So this is considered generally military procurement fraud. This has generally been the cybersecurity cases we've had so far have been, now there have been 2 settled under personal health information or the sensitive data that we've spent the first part of the program talking about. One, a contractor in Florida who was holding data for the Florida Medicaid equivalent, so children mostly, had the children's data. It was not even running on, it was on a end of life operating system, and needless to say, it was hacked. And all that data gotten out. And my husband likes to say the difference between security and privacy is you can restore security, but you can never restore privacy. Once a private information has gotten out, you're stuck, and that's the harm that we have to really focus on. Here, the military information, I'm not appreciative of the fact that if you don't have proper cybersecurity and you're doing government contracting, you're handing over what we've worked hard for to foreign threat actors. And it's absolutely true. I should have put a slide in with a picture. Our F-22 is so much like the FJ in China that the error that was made in the coding of the pilot's canopy is replicated. Like, there is no question that was stolen and built. And I mean, if you are in this industry, you may know that already, right? But the government at large, the civil side of the fence, has been going, oh wait, this is bad, and hence we have CMMC. Hence we're seeing enforcement. And to that government knowledge thing, the government decided to make it very clear that this was material to its contracts and that you are expected to abide by it through the Civil Cyber Fraud Initiative. So the bottom line is that DCIS is very focused on matters that affect the health, safety, welfare, and mission readiness of warfighters and combat units. So let's go to the next slide. And this is the Civil Cyber Fraud Initiative. This was the day. It was momentous in my marriage. I always know. I got a call from Will. He's like, we're finally going to overlap. And I was like, impossible. But this is not going to be material. But Lisa Monaco in October announced that they're going to do the CCFI. The CCFI will combine their expertise in civil fraud enforcement and procurement and cybersecurity to combat these cyber threats. And we're going to use the FCA to pursue cybersecurity related fraud. And if you knew anything about what the FCA was, that was a bomb. If you didn't, and most cyber people do not, it didn't make nearly the splash that CMMC coming out did. So we can go to the next slide. Thank you. So there's the CCFI, and important safety tip. Brian Boynton identified 3 ways that you could violate the FCA under this, which would be knowing failure to comply with cybersecurity standards. That's just, you have a standard, you know it, you don't comply with it. You're on the hook, you've lied to the government. Knowing misrepresentation, that's telling the government you've done it. Now, most people think of the third one, you don't report a cyber incident. Well, yes, that's the case, but it doesn't have to go to that level. You may never have had a breach, and you're still liable under this statute, which is pretty kind of hard for people to get their head around, because they think, well, then what's your damage? But my friend, there's no damage provision, no element in the FCA of damages. Remember, you're going to be on the hook for those, at least those penalties, and we're trying to quantify what damage you may have done by not properly following. So we can go to the next slide. I think I'm running out of my slides. So with that, I'll leave you to say I filed probably, I feel safe in saying, more of these than anybody in the country. I think I had a big leg up because of the Cyber+1 situation and understanding what it meant to do identity and access management, and understanding, because of what Scott has shared with you, it's not just so, like, I have cases, they're under seal, they're filed under seal to begin with, and I can't talk about them. Isn't that convenient for me? But you have cases where a company would not appear to be a government contractor who's holding military data. But if you're holding information about the blueprints of the Senate floor, if you're holding information about the location, the geolocation of senators or other government officials, that's something we don't want potential threat actors to have access to. So it's bigger than it sounds, and it all starts with assessing where is that information located and how secure is it. And I see so many companies that skip those steps and jump right into, well, do we need a better server? Well, let's build an enclave. Well, that's terrific. Build your enclave, but you've got to know what you've got to move into the enclave at some point. And I have 3 active cases where they did exactly that. They built an enclave and reported that they were now compliant, but they did nothing to find out where the data was that needed to be moved over, and it's still swinging in the breeze as we speak. So that's my purpose in being here. I really don't bring cases against people who don't know better, myself, but there's the time for saying I didn't know about this is kind of long past. So
thank you so much, Julie. Thank you for that incredible information. Time check. We have 11 minutes left. Kevin, I'm going to pass it to you before we get to the Q&A to talk about the next steps. How should people proceed? How should we go forward from here?
Yeah, I'll try to put a bow on this, and then if people have questions, they can start just raising their hands so we can start queuing them up. I know a couple were submitted ahead of time. I think Julie said it exactly right. Step 1 is to start now. You probably should have started a while ago. Step 2 is see step 1. Just go to the next slide. This is what we get called into all the time is your current state looks like something on the left, and it's overwhelming. You've got files, Julie, we've got a client that is involved in making military uniforms. You wouldn't think that's a big deal, but if they have to start ramping up production of military uniforms, it's probably sending a signal that something's going to go on if they're shipping some to a certain location, right? So all that data that you don't really think about, how does it all connect? It is interconnected. At the end of the day, we all do business with the federal government in some way, shape, or form, which typically ties back to the DoD. So your current state looks like on the left, and people just panic. They keep passing the buck, and they say, well, wait a minute, books on the left, that's finance, and those ones over there are inventory. So this isn't my problem. This is a community problem because data doesn't really belong to anybody per se. So they pass the buck. And they end up having, like my garage gets occasionally, it looks like the thing on the left. The desired state is the thing over there on the right. That's what everybody wants to get to, but they're so intimidated by the current state they don't get started. So that's step 1 is to pick up a few books, look inside of them, put a sticker on the back that says, here's what's actually in this book, and put it on the proper shelf to the right. But recognize that the one-time project of cleaning up the left will get you to the right. And then the second you have it done, you're going to have to start over again because somehow my garage never stays perfectly clean. Neither does your data because it's constantly moving, constantly changing. And what Scott talked about, what I talked about with the changing definitions of sensitive data, all that stuff. So you got to build a program. If you think of this as a project as one and done, you're going to continue to be probably have a problematic profile in terms of your overall data posture. So Scott, why don't you walk us through a couple things that people can do, because these are always interesting now that both you and Julie have scared the crap out of us. What can we do to get started to solve the problem?
Sure, and yes, thank you, Tony, for finishing. Yeah, why don't you just finish the whole list here, because I want to talk from a threshold question. The question is, whenever you do have data, and this relates back to the chart I had earlier, asking yourself, is this sensitive? How do I know if it's not? Okay, and that's the question that I ask my clients when I say, okay, great, we're going through all this data, we're trying to find the things that we need to spend the most time on, the 80-20 rule, where 20% of your sensitive data is going to consume 80% of your resources because it's the data that needs to be protected the most. Asking yourself, what qualifies as that 20%, and how do you know? And a lot of that is going to come out of your data inventory. That's why this is so important, because when you ask those questions, like I ask clients, well, where did this come from, and how do we know that it's legitimate to begin with? Because a lot of times when you get advertising and marketing data, a lot of times people don't want to know where it came from. They just want to know that it works. And that was a mentality we had before GDPR that had to go out the window, but unfortunately it still exists today. So long story short, having a very good idea of what qualifies as sensitive, depending on the context, understanding where it is, asking hard questions now so that you don't have to have long explanations later, is crucial. And the question is, ultimately, what am I doing with it? And what are the people that I've licensed this to or sharing this with, what are they doing with it? At the end of the day, that's really going to define how you develop your data protection program.
And Scott, one quick comment on that defining, and then we'll go to Q&A. Another example, another client, what is sensitive to that organization is they're in the logistics business. It's the weight of a pallet because they do business with the DoD. And I can, from a weigh bill, if I know the weight of a pallet, I can probably deduce that it's military equipment that's on that particular truck, even though it's a commercial trucking organization. So to your point, define and value personal and sensitive data for your organization. It's going to be specific to your organization. Don't just lean on the list of, well, my credit card numbers are safe, so I'm PCI compliant. Well, I know where my employee data is. What is the things from your organization, especially when it applies to doing business with the DoD? Back to what I talked about with the uniforms, you can also, weight of a pallet can also be incredibly sensitive.
Agreed.
All right, we do have a few questions, so this is going to be rapid fire Q&A. We have 6 minutes left. Julie, I think this one's for you. What's the most common omission that exposes me to FCA liability?
So if you're doing most common, the garden variety thing I see is you've been signing that you are receiving controlled unclassified information, which says right there in its name, it's not classified, right? So they don't think it's that big a deal. It's quite a big deal. It's covered defense information. You've been signing that you're compliant and you're not compliant, and you don't have a system security plan, and you don't have, the very first step of a system security plan is assess the campus, right? Assess the campus, everything we've been talking about. And I would say that the failure to get people in who can help you do that, you wouldn't go to your GP and ask them to set your leg or do brain surgery. And IT is just as differentiated as is law, as is medicine. And I think it's very easy for us not to know that if we're business people or lawyers, but you can't just ask your IT guy who makes your system run, your system administrator, to assess your campus for cybersecurity. You just can't do it. You can't expect it to be right. And I think the most common thing I see is people who just try to brush that down to existing IT and not take on anything else. It never works. I'm supposed to be rapid fire, and I'm not good at that. Sorry.
All right, Scott, I think this one's for you. I'm not sure where all our sensitive data resides. How do I practically begin building a defensible data inventory, as you discussed?
I would find the smallest system that you can address, whatever that might be, and start from there. So basically, you think about all the systems. You may have 30, 40, 50 systems that process personal information for whatever reason. Going to the very smallest one you can, maybe it's not terribly important, but you can get your arms around it, attack that one first, and go through this process almost as an exercise. I think you're going to find once you do that one, the next one is going to be a little bit easier, and your knowledge will grow and your experience will grow. Don't try the hardest thing first, like the HR system. That's a beast, and you really want to work your way up to it.
Great. Very succinct. Hey, Kevin, someone wants you to elaborate more on the concept of thinking program, not project, when addressing data privacy and security risk.
It goes back to the picture that I showed, and I find a lot of people think that this is a one and done problem. And to me, it goes back to the early days of identity management, which is really where I started my career in this software space. People thought it was a project. I would go ahead and get everything hooked up once and be good to go. And fast forward 20 odd years, and now you have teams of people that work on identity and access management, and they realize it's an ongoing program inside their organization. Data has to be looked at the same way. So it is not a project that you go ahead and say, I am now CMMC compliant. I can check the box and now I move on to the next project on my list. It is a data governance program that addresses the sensitivity of your data, the risk associated with it, and how you're managing it. So program, not project.
Great. Final one here, Scott. What should we be asking our vendors and partners to ensure they're not introducing compliance or security risk into our data ecosystem?
You should be asking them, what have they done prior to your relationship to protect the data that's already under their control? If they don't have a very crisp answer, whether that comes through on their SOC 2 report or on an ISO certification, or they just can't answer some very basic questions like the ones I just cited earlier in my discussion, then you have a problem, and it's better to find out then than after you've ingested that data and found out that you shouldn't have had it in the first place.
Great questions, everybody. Thank you. Great answers. We're going to move on to the final page here. Your final thoughts, Julie. Why don't you start us off? What's your final thought for key takeaways?
That's why I laughed when Kevin said C.I. point number one, point number one, and then second point, see point number one. So the best time to have started this was 7 years ago. The next best time to start is now. At least if someone comes to me to whistleblow about the fact that you've got the barn door wide open and no walls in the back, at least you want to be able to say, look, we realize that and we're on top of it. We're trying our best to get compliant. That's going to go a long way. The DOJ also stresses self-reporting, going to the DOJ and saying, hey, we've got issues. We realize that we have legacy issues. We're taking care of them. That won't get you off the hook totally, but it does speak a lot to your current state of mind or CENTER. And so that's another thing. But again, don't let another day go by that you don't start doing something about this, because it's a serious problem that needs attention immediately.
Exactly. Don't wait. Scott, what do you got?
Start debt inventory now, and it's okay to get surprised. What it's not okay is when the bad guys break into your system and then you get surprised.
Yeah.
Finally, Kevin.
Since I already got a question on this one, I'm going to choose a different final thought because I can. And that's going to go back to what Julie was talking about and Scott was talking about. We'll use, I think this was Reagan era stuff, trust but verify. Independent third-party verification is what you want, not a 37-tab Excel spreadsheet that somebody went ahead and filled out. So when you're talking about supply chain risk or other pieces, my team has to fill out those 37 pages. Great, I filled all that stuff out, but it has an actual third party gone in and audited and verified that you have the processes in place and things are properly protected. That will go a long ways in helping you with a lot of the risk that was associated that both Scott and Julie scared the crap out of us about, because you can say, I've had independent third parties in here and we're actively making progress, versus Louis and IT said we were okay.
Great points, everybody. What a fantastic discussion. That is our time. Thank you to our panelists for joining us and sharing your unique insights. And thank you to everybody for attending today, asking these important questions. We hope you found it valuable and leave with more insight into protecting your sensitive data and staying compliant. This website was recorded and will be sent to all attendees to watch again or share within your organization. You can also explore more by visiting any of these wonderful web pages. And here's everybody's information if you want to reach out to them and ask them your own questions. Goodbye, everybody.